Thank you very much indeed for coming to tonight on a pre-Christmas talk on a rather serious and solemn topic. It's very good to see so many people here from so many different disciplines, walks of life. It's a great honour for us and for the Bar Centre, which you'll learn a little bit more about tonight. Well, I once went to hear the famous linguist and political radical Noam Chomsky give a lecture to over 1,000 people. His introducer began by telling us, "I'm not much of a linguist, but," and then proceeded to talk for close on 40 minutes, thereby enraging everyone present. Now, I don't intend to make that mistake tonight, but I will just say a few words to put this event in context. You will have seen coming in, perhaps even recognized the BIOS logo, the image of Hippocrates. That great man wrote in his law the following words: "Medicine is of all the arts the most noble, but owing to the ignorance of those who practice it and of those who inconsiderately form a judgment on them, it is at present far behind all the other arts. Such persons are like the figures which are introduced in tragedies, for as they have the shape and dress and personal appearance of an actor, but are not actors, so also physicians are many in title, but very few in reality." These strong words remind us, even in the light of extraordinary medical advances, that those who profess to be doctors are noble insofar as they are bound by an internal ethic which makes sense of their practice. Doctors and healthcare professionals more generally, like everyone else, live in particular cultures which help to form their outlook on the world and their responses to ethical dilemmas. And sometimes the cultures in which they live promote, with or without their help, ideas which are antithetical to the internal goals of medicine. One idea we all have to grapple with is a certain naive conception of autonomy and its importance. Autonomy, of course, has a crucial role in medical ethics, since the competent patient has first responsibility for his or her health, a responsibility which is then delegated to, for example, a doctor. Doctors should not treat competent patients against their will. But the naive conception of autonomy goes much further than this, failing to appreciate the very point of autonomy, which is the pursuit of health and other forms of genuine human fulfillment. G.K. Chesterton noted over 100 years ago, "We are fond of talking about liberty, but the way we end up talking of it is an attempt to avoid discussing what is good. We are fond of talking about progress. That is a dodge to avoid discussing what is good. We are fond of talking about education. That is a dodge to avoid discussing what is good. The modern man says, let us leave all these arbitrary standards and embrace unadulterated liberty. This is logically rendered, let us not decide what is good, but let it be considered good not to decide it. He says, away with all your old moral standards, I am for progress. This, logically stated, means let us not settle what is good, but let us settle whether we are getting more of it." So where does BIOS fit into this picture? Our aim is to go deeper in the research we do. We cannot understand the surface of what is happening in our culture in regard to medicine and related areas without examining the metaphysical and ethical depths. The aim of the BIOS initiative is to encourage and publicize new work in bioethics, in particular work by early career researchers from a range of different disciplines who are able to explore issues in bioethics in the light of the traditional ethos of the healthcare professions, and recover the sense of the specialness of these professions, which will always be under pressure from interests outside of healthcare properly understood. We encourage you all to visit our website and sign up for updates on our work. A first taste of this work of a more empirical nature can be found in this excellent new publication. You should all have had one on your seats, so please take one home. The Provision of Nutrition and Hydration to Vulnerable Patients. Well, to the main event. We're delighted to welcome Professor John Keown of the Kennedy Institute of Ethics, Georgetown University. He's flown all the way from America, so we're extremely privileged to have him. Professor Keown graduated in law from Cambridge and took a doctorate in law at Oxford, after which he was called to the Bar of England and Wales, Middle Temple. He became the first holder of a lectureship in the Law and Ethics of Medicine at Cambridge University, where he was elected to a fellowship at Queen's College and later senior research fellowship at Churchill College. In 2015, he was made a Doctor of Civil Law by the University of Oxford in recognition of his contribution to law and bioethics. He's published widely in the Law and Ethics of Medicine, specializing in issues at the beginning and end of life. The second and heavily revised edition of his widely acclaimed book, Euthanasia, Ethics and Public Policy, An Argument Against Legislation, was published by Cambridge University Press last year. His research has been cited by distinguished bodies worldwide, including the United States Supreme Court, the Law Lords, the House of Commons, the House of Lords Select Committee on Medical Ethics, and the Australian Senate. He has served as a member of the Ethics Committee of the BMA and has been regularly consulted, not least by legislators and the media, and myself, on legal and ethical aspects of medicine. He is, in short, that most wonderful thing, a lawyer who really understands ethics. Well, we're extremely grateful that he's generously agreed to speak to us tonight on the topic of law, life, and bioethics, some challenges and opportunities. Thank you.
Well, thank you, Anthony, for that very kind introduction, and thanks to you and the BIOS Centre for your kind invitation to be with so many wonderful people this evening. And I wish the Centre, it's a very exciting venture, and I'm sure we'll do very valuable work. I thought tonight I would share with you one of my latest publications. It appeared just a few weeks ago in a volume entitled Philosophical Foundations of Medical Law, published by Oxford University Press. And it's edited by Andelka Phillips, Tana de Campos, and Jonathan Herring. And my particular focus in this paper and in this presentation is on the beginning and end of life, and my suggestion that the law is ethically incoherent in a number of important respects. Now, the law has historically been informed by the principle of the sanctity or inviolability of human life. And I can recommend an excellent account of that principle and its incorporation in the law in the book by Dr. Neil Gorsuch called The Future of Assisted Suicide and Euthanasia. Neil Gorsuch is, of course, now Justice Gorsuch of the United States Supreme Court. To the extent that English law has over the last half-century departed from that principle by accommodating utilitarian thinking and a dualistic understanding of who is to count as a subject of justice, thereby excluding certain human beings from its protection, the lines it has drawn are both arbitrary and liable to further erosion. So my presentation is divided into three parts. The first part suggests it's philosophically incoherent for the law to calibrate its protection of human life according to arbitrary stages of human development, such as birth, viability, the 14th day after fertilization, and implantation. The second part contends that to the extent that the law permits life-sustaining treatment to be withheld or withdrawn from incompetent patients, whether infants or adults, on the ground that their quality of life is insufficient, and even with an intent to hasten death, it again displays ethical incoherence. And the final part maintains that were the law to endorse intentionally assisting suicidal refusals of treatment or of food and water, or to permit physician-assisted suicide for the terminally ill, its ethical incoherence would be aggravated. So first then, the protection of the law, the law affords or does not afford to life before birth. It is clear law that a physician who administers a lethal injection with intent to end the life of a child who has been completely born alive commits the crime of murder. Glanville Williams, the eminent criminal law jurist from Cambridge, explained that the meaning of birth is taken in the English cases to mean complete extrusion from the body of the mother. The umbilical cord need not have been severed, but no part of the child must remain within the parts of the mother if it is to be regarded as born. Yet the law's protection of the child before she reaches that geographical point has been seriously compromised over the last 50 years, mainly as a result of legislation, but partly as a result of judicial decision. The lines drawn by the law to calibrate the protection of life before birth simply lack ethical coherence. So we'll look in turn at live birth, viability, the 14th day, and implantation. Firstly, complete live birth. While the law prohibits the intentional destruction of a child after she has been completely born alive, it sometimes permits her to be intentionally killed during birth. In 1929, the Infant Life Preservation Act was passed to protect children during delivery, who fell into a gap between the crime of using means with intent to procure miscarriage, contrary to Section 58 of the Offences Against the Person Act 1861, and the crime of homicide. The 1929 Act made it an offence intentionally to destroy a child capable of being born alive before it had an existence independent of its mother, unless its destruction was for the purpose only of preserving the life of the mother. However, the Abortion Act 1967, as amended by the Human Fertilization and Embryology Act 1990, provides that when a registered medical practitioner terminates a pregnancy in accordance with the Abortion Act, no offence is committed against the 1929 Act. Consequently, provided an abortion is performed in accordance with the Abortion Act, a physician commits no crime by intentionally destroying a child who emerges alive, and even if capable of survival, before it is completely born. Now, there is broad agreement among bioethicists that there is no significant ethical distinction between abortion and infanticide. The consensus embraces philosophers who oppose both, such as Professor Christopher Kayser, and I can highly recommend his excellent book, The Ethics of Abortion, now in its second edition, and those who endorse both, such as Professor John Harris. As John Harris has observed, it's not plausible to think that any moral change occurs during the journey down the birth canal, and, quote, the geographical location of the developing human, whether it's inside the womb or not, is not the sort of thing that can make a moral difference, unquote. More recently, Achas Burin has, by contrast, attempted to defend what she calls the bright line that the law draws at birth. This is in an article she wrote in the Medical Law Review in 2014. She has argued that, quote, expressing sentience in the world is essential for the attainment of personhood, unquote. She writes that legal personhood begins when a child sees the light of day, and that this kind of sensory experience is integral to attainment of personhood. Expressing sentience in the world is, we are told, central to legal concepts of personhood. Her ambitious argument invites many questions. For example, just how bright a line is birth? What if only the baby's head emerges, but she sees the light of day? What of babies removed from the womb for surgery, who are then replaced? Are non-human creatures which express their sentience after birth persons? Is it not murder to kill a living child who has been delivered unconscious? Yes, it is. Burin claims that the actus reus of murder, the conduct element of the crime of murder, applies only postnatally. But even leaving aside the live birth murder rule, under which someone can be convicted of murder if the injuries inflicted before birth result in the death of the child after birth? What about fetal homicide statutes of the kind one finds in various American states, which criminalize killing the fetus before birth as homicide? And we should note that historically, the law has severely punished the intentional destruction of the child throughout pregnancy, and does so today, absent compliance with the Abortion Act 1967. Moreover, why should it be thought necessary to express one's sentience to qualify as a person? What if a newborn child, or indeed an adult with a condition like locked-in syndrome, is incapable of any expression? What if a baby's sensory experience and expression after birth is, perhaps due to brain damage during birth, less than it was before birth? What if a baby were born into an environment, such as an opaque incubator, in which she received either no stimuli or fewer than she did in the womb, where she regularly heard her mother singing lullabies to her? Burin writes that the womb is more akin to a cupboard, a peculiar way to describe an organ of the pregnant woman, not least because it elides her from the relationship. But if the child were delivered in the dark and placed in a cupboard, would it not be a person? If adults were placed in an environment with no stimuli, or plugged into Robert Nozick's experience machine, which Burin incorporates into her argument, would they lose their personhood? This machine and the womb, we are told, are controlled environments. But what about children or adults living in other controlled environments, perhaps for reasons of health or punishment? If, quote, interaction with the world is the key to personhood, unquote, do such persons, or do such humans, lack personhood? Further, what degree of sensory experience, and of which sensory experience or experiences, is essential to personhood? And do those with lesser degrees of sensory experience, such as those born deaf-blind, enjoy lesser degrees of personhood? Finally, Burin writes, it's impossible to be a person when contained entirely within the person of another. But if you were somehow shrunken in size and placed into someone else's body, like in the movie The Fantastic Voyage, would you lose your personhood? You may remember in that movie, it's important to save some person, someone who has important knowledge. They have some tumor in the brain, and in order to destroy the tumor, they shrink these doctors in a little submarine and inject the submarine into the patient, and then they are able to zap the tumor in the patient's skull, and they're then later expanded back to their normal size. Or did they lose their personhood when they were injected as tiny human beings into that person's body? In short, it seems to me that Burin's entire argument is, with respect, implausible. The law then, by attaching crucial significance to complete live birth, draws an ethically incoherent line. It regards the physician who kills a child before complete live birth as meriting payment, but the physician who kills the child seconds later as meriting prison. In England, a mandatory life sentence, no less. In the United States, abortionist Dr. Kermit Gosnell was given 3 consecutive life sentences for murdering 3 children who had survived abortion by severing their spinal cords. The Philadelphia district attorney commented that he had witnessed much senseless violence and cruelty, but that this case was arguably the most gruesome, the most vile. Had Gosnell killed the babies during birth, he would not have been liable for homicide. But would his actions have been any the less gruesome and vile? Reflecting on the case, Kate Greasley asked in a paper in the Journal of Medical Ethics in 2014, but she did not answer, whether birth represents a morally relevant boundary. She argued that opponents of abortion, who hold that all abortion involves the killing of a person, are disingenuous if they exhibit amplified moral horror at Gosnell's killings, and that their use of the case is, quote, a contradiction of their most fundamental premise that an inviolable human life begins at conception, unquote. But this is not so. There is nothing contradictory in holding that all intentional killings are seriously wrong, but that some are worse than others. That it is, for example, wrong to kill a sleeping person painlessly, but worse to torture someone to death. Finally, when a pregnancy is terminated under the Abortion Act, the child may lawfully be killed before or during birth, even if she is capable of survival. The law allows the termination, therefore, not only of unwanted pregnancies, but of unwanted children, even if those children are desperately wanted by scores of prospective adoptive parents. Even on a utilitarian calculus, why does the happiness of the prospective parents and of the child not outweigh the wish of the mother that a viable child be put to death? Let us turn now from the line drawn at birth to the line drawn at viability. The grounds for abortion under the Abortion Act, as amended, are very extensive for the first 24 weeks of pregnancy, permitting virtual abortion on request. Even in the early 1980s, David Steele, the Act sponsor, commented that abortion was being used as a contraceptive. But the grounds are less extensive after the 24th week. Abortion after the 24th week is permitted when two registered medical practitioners believe in good faith that abortion is necessary to prevent grave permanent injury to the physical or mental health of the pregnant woman, or that the continuance of the pregnancy would involve risk to the life of the pregnant woman greater than if the pregnancy were terminated, or that there is a substantial risk that if the child were born, it would suffer from such physical or mental abnormalities as to be seriously handicapped. Precisely how restrictive these limitations are will turn on the court's interpretation of unclear terms like substantial risk and serious handicap, which some abortionists think, remarkably, includes such relatively minor and largely remediable conditions as hair lip and cleft palate. The line was drawn at 24 weeks to distinguish unborn children who are capable of survival, if born, from those who are not. What is the moral distinction between an unborn child who is and one who is not capable of survival if delivered? The law prohibits the intentional killing of infants after birth, whether or not they are viable. As Glanville Williams observed, quote, "If an aborted fetus is alive, it is a person, no matter how short the period of gestation," unquote. Similarly, at the other end of life, the law prohibits the intentional killing of those who may have only hours or even minutes to live. Why, then, does it distinguish between killing unborn children who are viable and those who are not? The question acquires added traction when we recall a point made earlier, that if a child emerges alive for an abortion performed in accordance with the Abortion Act, the law allows her deliberate destruction before complete live birth, even if she is viable. Where, then, is any supposed higher moral status attaching to viability? The lines drawn at complete live birth and at viability, which made some sense when they were aspects of a panoply of overlapping protections for human life, from fertilization to live birth, ceased to make sense when that panoply was ruptured by the Abortion Act and the Human Fertilization and Embryology Act. Let's now look at a third line drawn by the law, the 14-day limit of human development in the laboratory. A third line of legal demarcation for which sound ethical support is lacking concerns the time limit for destructive research on human embryos in vitro. The Human Fertilization Embryology Act permits such research, subject to specified regulatory approval, up to the appearance of the primitive streak, the longitudinal groove that develops in the gastrula during the development of bird and mammal embryos. This streak, the Act provides, is to be taken to have appeared no later than the end of the 14th day after the process of creating the embryo began. A central moral argument in favour of distinguishing between embryos before and after the development of the primitive streak is the argument from twinning. It's argued that the possibility, before the formation of the primitive streak, that the embryo may split into twins means that it's not a human individual. As some members of the President's Council on Bioethics argued in its report on human cloning and human dignity in 2002, only after 14 days or the formation of the primitive streak can the being in question be anything other than a single being. However, as other members of the Council countered, there is the obvious rejoinder that if one locus of moral status can become two, its moral standing does not thereby diminish, but rather increases. More specifically, the possibility of twinning does not rebut the individuality of the early embryo from its beginning. The fact that where John alone once was, there are now both John and Jim, does not call into question the presence of John at the outset. And as someone called John, that's an argument I thoroughly sympathise with. Two other arguments often adduced to support the 14-day limit are that the incidence of natural abortion is high and that the limit marks the end of the implantation stage. However, one cannot sensibly reason from the fact that a particular proportion of human beings die at a certain stage of their lives to the ethical conclusion that their lives lack value and we are therefore justified in ending them. Nature is not a moral agent, but we are. Would a high incidence of infant mortality justify infanticide? As for 14 days marking the end of the implantation stage, why is this thought to be morally relevant, especially when the embryos subjected to research are never going to be implanted anyway? The end of the 14th day, a line drawn for utilitarian reasons to facilitate research on human embryos, is a marker that is as unstable as it is arbitrary. If the pursuit of improvements in scientific knowledge about early human development, human diseases, and the treatment of infertility justify research up to the end of the 14th day, they justify research beyond that time. Indeed, the utilitarian case for breaching the barrier has already been made. John Harris has argued that the overwhelming consensus of scientific opinion holds that much of considerable scientific and therapeutic importance could be gained by extending the 14-day limit, with what he refers to its bizarre origins, to 21 days. And he underscores the incoherence of the 14-day limit by noting that the law freely allows abortion up to the 24th week. Recognition of the arbitrariness of the 14-day limit does not, of course, mean the limit should be extended. One could equally argue that the arbitrariness should be resolved by prohibiting the intentional destruction of any human being, whether in vitro or in vivo. Now to a fourth line, which is drawn by the law and is also ethically incoherent. Implantation. Another legal distinction lacking any cogent ethical basis is that between destruction of the human embryo before and after its implantation in the womb. In the Smeaton case in 2002, Mr. Justice Munby, as he then was, held that sections 58 and 59 of the Offences Against the Person Act 1861, which respectively prohibit the use and supply of means with intent to procure miscarriage, did not bite before implantation. Now, that judgment has been subjected to extensive criticism elsewhere. Suffice it to ask here, what principal justification could there be for drawing a legal line at implantation? When Parliament enacted those sections, its purpose was undoubtedly to protect human life from fertilization. It was well known by 1861 that human life began at fertilization, and medico-legal experts had long been pressing legislators to enact stricter laws to protect the unborn from that point. It was also well known that attempts to procure abortion were risky to women. Are we seriously to believe that the legislature intended to protect the unborn and women only after implantation? Are we suppose that Parliament wished, as Victor Tunkel once vividly put it, to grant a free-for-all moratorium of a week or more after intercourse, during which every sort of abortionist could ply his craft with impunity? Yet Smeaton effectively amends the 1861 Act to render lawful the modern practice of doctors and pharmacists, without complying with the Abortion Act, of using or supplying means to prevent implantation. As Sally Sheldon has observed, the legal line drawn at implantation falls woefully short of what clear moral reasoning requires. In short, the law's protection of early human life is philosophically unsound. The lines it draws at implantation, 14 days, viability, and birth seem grounded on little more than utilitarian pragmatism, confined with philosophical dualism to facilitate the destruction of preborn human life. Now let's turn to the second part of my presentation, the non-treatment of incompetent patients, including children and adults. First, I'll say a little about non-treatment of infants. Although the law continues to prohibit as murder the intentional administration of a lethal injection to kill a child after she has been completely born alive, a series of judicial decisions has seriously undermined that principle by holding that it can be in the best interests of a child for life-prolonging treatment to be withheld or withdrawn on the ground that the child's quality of life is not worthwhile. For example, in the Charlie Gard case, Mr. Justice Francis, having cited a previous case in which the judge had found that the lives of the patients in question had some value and were worth preserving, held that, by contrast, Charlie's quality of life was not one that should be sustained. The Court of Appeal endorsed the judge's finding that the treatment proposed by his parents would simply prolong Charlie's awful existence. It was reported that counsel for the hospital, which favoured withdrawal of Charlie's ventilation, reportedly told the Court of Appeal that the parents' wishes would result in significant harm to Charlie, namely a condition of existence which is offering the child no benefit, and that it was inhuman to permit that condition to continue. Why wasn't this equally an argument for giving Charlie a lethal injection? Is it not ethically incoherent for the courts to hold that it's unlawful intentionally to hasten the child's death by an act, but lawful to withhold or withdraw life-prolonging treatment on the ground that continued life is no longer in the child's best interests, and especially if the intention is to hasten the child's death? Now let's turn to the non-treatment of incompetent adults. A similar question arises in relation to withholding or withdrawing of treatment and tube feeding from mentally incapacitated adults. While it remains unlawful to administer a lethal injection to such patients, it's lawful to withhold or withdraw treatment, including tube feeding, on the ground that continued life is no longer in their best interests. In Bland, the law lords held that tube feeding could lawfully be withdrawn from a patient in a persistent vegetative state. 3 of their lordships thought the intention in stopping his tube feeding would be to kill him. If they were right, and if the case held that notwithstanding such an intent, the tube feeding could nevertheless lawfully be withheld, then it clearly left the law ethically confused. As Lord Mustill, one of the 5 judges, famously and aptly observed, the case left the law in a morally and intellectually misshapen state. The incoherence may have been largely resolved by the Mental Capacity Act 2005, Section 4, subsection 5 of which provides that where the determination of best interests of a mentally incapacitated adult relates to life-sustaining treatment, the person making the determination must not, in considering whether the treatment is in the best interest of the person concerned, be motivated by a desire to bring about his death. Even if that act does rule out the withdrawal of treatment with intent to kill, however, ethical incoherence remains, tracking that in relation to the determination of the best interests of infants. There would appear to be nothing in the definition of best interest in Section 4 of the Act to prevent carers or courts from judging that continued life is no longer in the incompetent adult's best interests and that he or she would be better off dead. Indeed, Section 4 is phrased in such subjective terms as to the wishes, feelings, and values of the person and of others as to what is in the person's best interests, that it appears to accommodate such judgments. And now the final part of my presentation, future incoherence in the law. We'll look first at physician-assisted suicide by refusing treatment or food and water. In a number of cases, the courts have observed not only that competent patients have a right to refuse treatment, which right is, it seems to me, largely uncontroversial, but also that this right is absolute, which is highly controversial. If the right to refuse treatment were truly absolute, then it would include a right to refuse treatment precisely in order to end one's life. It would appear that suicide may have been the intention of the patient in the case of Ree B, whose request that her life-prolonging ventilation be withdrawn was upheld by the courts. If, however, patients have a right to end their lives by refusing treatment, and if doctors have a duty to assist them, or at least if doctors act lawfully by intentionally assisting them, then the law against assisting suicide is seriously undermined. How can the law sensibly prohibit physicians from intentionally assisting their patients from ending their lives by an act, but permit them, if not require them, to do precisely the same thing by deliberate omission, especially when the line between act and omission may be hazy, as in disconnecting a ventilator? Despite their incautiously sweeping statements, however, it's far from clear that the courts have held either that patients have an absolute right to refuse treatment, that includes a right to end their lives by refusing treatment, or that doctors may intentionally assist them to hasten their end. In the case of Ree B, for example, the judgment simply does not engage with the issues. Moreover, there is authority that there is a duty to prevent suicide in certain circumstances. It may be that if a patient's refusal is clearly suicidal, as it would be if the patient refused food and water to hasten their death in the normal case, a doctor could act lawfully with the sole intention of palliating the patient's suffering while the patient dehydrated to death. An intention to palliate suffering should not be confused by the law or by the doctor with an intention to assist suicide. Interesting, a few years ago, and I discussed this in the second edition of my Euthanasia book, the Royal Dutch Medical Association and the Dutch Nurses Association issued guidance to their members saying that it was perfectly ethical and proper and lawful for them to assist patients who refused food and water in order to end their lives. the guidance says this did not engage questions of suicide or assistance in suicide because refusing food and water to end your life was not suicide. Suicide required an act. But that guidance is clearly flawed because, as I demonstrate in the book, I devote a chapter to this Dutch guidance. It is perfectly possible to commit suicide by deliberate omission. Indeed, there are a number of cases I cite in that chapter of people who ended their life by starving themselves to death. Not necessarily in the hospital context, but by walking out into a forest and just stopping eating, and often keeping a diary of their days as they starved themselves, dehydrated themselves to death. And those deaths were ruled as suicide by coroner's courts. I also cite Justice Scalia of the US Supreme Court, who said, just as it would be suicide if you went to the seaside and threw yourself into the sea in order to end your life, it would equally be suicide if, while you were out sunbathing on the beach, you decided to end your life by allowing the sea to come in and drown you. There would be no distinction in law. Both, he said, would be cases of suicide. So it seems to me the Dutch are quite wrong by suggesting that one may not commit suicide by refusing food and water, and that the doctor may not assist suicide by helping the patient to do so. Now let's turn to physician-assisted suicide for the terminally ill, which seems to be perennially in the news in the UK. Attempts to introduce bills fashioned on the Oregon Death with Dignity Act. Over the past quarter of a century, the campaign for voluntary active euthanasia, or VAE, has rebranded itself as a campaign for death with dignity, which seeks, for now, physician-assisted suicide, PAS, for the terminally ill. Oregon-style bills have been introduced in Parliament on several occasions, and attempts have been made to persuade the courts that there is a right to assisted suicide under the European Convention on Human Rights, or a parallel English version of those rights. If such a bill or such a case were to succeed, it would inflict further ethical incoherence on the law. If there is a right to die, how can it be sensibly be limited to those who are terminally ill, whatever that means? And those who can end their lives with the help of a physician, what about those unable to end their lives even with the help of a physician? For if the principles of respect for autonomy and beneficence justify PAS, they justify VAE, especially for those unable to end their lives even with physician assistance. If those principles justify a hastened death for the terminally ill, they justify a hastened death for the chronically ill, who may have many years of suffering to endure. The narrower focus of the contemporary campaign seems little more than a clever tactical ploy to get a foot in the door. It has proved effective in several US states. Now there are 10 jurisdictions which allow physician-assisted suicide, but not as yet in the UK. UK law may then continue to resist the invitation to admit yet another ethically incoherent guest. What about voluntary euthanasia? If the law were to allow such a guest to cross its threshold and permit voluntary euthanasia, the law would not only logically commit itself to permit voluntary euthanasia, but also non-voluntary euthanasia. The logical slippery slope argument has been explained and defended elsewhere, and I have a whole chapter on the logical and empirical slippery slope arguments in my book. Suffice it to say here that the ethical case for voluntary euthanasia rests not only on the principle of autonomy, but also on the principle of beneficence, and that the absence of autonomy does not cancel the duty of beneficence. So if euthanasia can be a benefit for a patient who can request it, and the doctor has a duty to confer that benefit on the patient, then the doctor equally has a duty to confer that benefit on patients who can't ask for it. The few attempts to refute this logical argument have proved wanting. One attempt was made in my debate with Emily Jackson, the book Debating Euthanasia, published by Hart, in which she tries to respond to the logical argument, but with respect, unconvincingly. So in conclusion, I've suggested that the law in relation to protection of human life at its beginning and at its end exhibits profound ethical incoherence. It's also suggested that if legislators or judges were to hold that physicians could intentionally assist suicidal refusals of treatment or to endorse a right to PAS for the terminally ill, the law's ethical incoherence would be aggravated. Could it not be argued that the law regularly draws arbitrary lines and that this does not amount to ethical inconsistence? The counter-argument, however, is that some lines are necessarily determined by prudential and pragmatic considerations, such as whether the speed limit on a certain road should be 60 or 70, and those decisions may involve a certain degree of arbitrariness. By contrast, however, the determination of who is a subject of justice and whose basic rights, not least the right not to be intentionally killed, are entitled to protection of the law is a question of fundamental principle, not a matter for arbitrary judgment. Sally Sheldon has rightly noted that we need to be able to determine when someone acquires full human rights that accompany legal personhood, and it's important to ensure that they are grounded in careful consideration, informed by clear moral reasoning, and a solid medical evidence base. Unfortunately, she gets off on the wrong foot by quoting, again, Glanville Williams, his misleading statement that abstract human life does not begin, it just keeps going. Well, of course, while the life of the human species continues, the lives of individual human beings, like Glanville Williams, begin and end. If, as the principle of the inviolability of life holds, all human beings share an intrinsic equality and dignity and enjoy a right not to be intentionally killed, there is no room for drawing arbitrary distinctions between human beings so as to deny them that right, whether on the basis of sex, race, ethnicity, sexual orientation, nationality, religion, physical or mental disability, age, or stage of development. Thank you.
Well, thank you very much indeed. Just occurred to me actually as he was giving the talk, we're talking in an anatomy museum, so people used to look down here on operations of corpses and dissections, more matters of life and death. Now, we have a short time for some questions. I should say we're being filmed, so don't let that threaten you. This may never see the light of day, but I feel obliged to say that. So I'm going to give you the microphone.
Thank you very much, and I agree with sort of 98%, so this is about the 2%. You rightly characterize many distinctions as being arbitrary, but it seems to me some distinctions don't require a different view of the sanctity of life of the person, and I'll give two instances. One, in relation to viability, it seems to me that after viability, if you want to destroy a fetus after viability, you need to have feticide, intentional feticide. Whereas before viability, it may be that you have that intention, but it may be that you have the intention to extract the fetus without the intention to kill, which might also be a wrong intention, but it seems to me a different one, and therefore a matter of principle. And in relation to feeding of those who are who refuse treatment. Or other kinds of treatment in a suicidal way, it also strikes me that you might, even though you think that being suicidal is one reason to override their refusal, the fact of overriding a refusal is itself something which requires some kind of authorization by the state, that generally, in regard to one another, we're equals, and that in order to coerce in some way, you need to have authorization. And that authorization may be given by the state, but there may be circumstances in which it's not given. So even though being suicidal may be a reason to coerce, the fact of coercion makes a difference between cases of giving treatment for a suicidal patient, for example, under the Mental Health Act, and cases where you actively assist the suicide of a suicidal person. Those seem to me the differences of principle, not just differences about in relation to the sanctity. So it seems to me that there are some matters of principle here, at least in some of these distinctions, and not only arbitrary distinctions.
To take the second point first, I'm not really in the paper addressing so much overriding refusals of food and water. My point is that it's very important that the courts hold that there is no right on the part of the patient to be assisted in ending their life in that manner. The question of whether the doctor should then force treatment or food on a patient is another matter, and I would want to give that separate thought. It may well be that one wouldn't want to do that as a general policy. So my concern is more that the courts must be very alive not to confuse the standard right to refuse treatment where the patient's saying, you know, this treatment would be too burdensome, or the benefits wouldn't be adequate, or I can't afford it, whatever the case is, with suicidal refusals, because if they do, then of course the next question follows. Well, if I have a right to make this decision, you have a duty to assist me to carry it out. So that distinction's being lost, I'm afraid, in the court, and I think in the medical profession, as the Dutch guidance showed. They just don't see this as being suicide at all. So I'm very concerned about that. In relation to the abortion, but of course it is possible by removing the unborn not to intend its death. That's true both before and after viability. So I'm not sure viability comes very much into that issue. The key thing, I think, is the importance of the intention. So the intention, whether before or after viability, if it's to destroy the child, is equally objectionable. But no one seems to have explained why the law regards viability as ethically significant, especially when the law goes on and says, well, yes, but of course you can destroy the child even when it's viable in certain circumstances. One can look again at the case of Roe and Wade, in which the judges simply invented the significance of viability without giving any significant reason. Oh, well, after that point, the child presumably has the capacity of meaningful life. Very slipshod reasoning, it seems to me. So I think I'm right in pointing out that the viability is just an incoherent ethical line for the law to draw.
I was brought up to beware of the word incoherent. You might say it's an incoherent word. What does it mean? Does it mean the principles are self-contradictory, or do you mean that what is being said is not clear, simply? What does it mean exactly, incoherent?
Well, I think I could say that the law is being contradictory. It is saying, on the one hand, it subscribes to the principle of the sanctity of life in saying that one may not intentionally kill people in these situations, for example, but then in the same breath says it's fine if you intentionally kill them by omission. That just seems to me to be contradictory, and in that sense incoherent. That human beings have a right not to be intentionally killed by an act, but they have no right not to be intentionally killed by deliberate omission. I see no moral sense in that. And even the judges, when pressed, can't see any moral sense in that either, recognizing it leaves the law in a morally and intellectually misshapen state. And that's not a good state for the law to be in.
In a recent article, Crean described best interest as legal fiction. It's at the center of the Mental Capacity Act. What is your view about the validity of best interest?
Well, I think the problem with the Mental Incapacity Act, or the Mental Capacity Act, is that it has this very open-ended, subjective notion of best interests in terms of what a person thought their best interests were or what somebody else thinks their best interests are. So it's not defined in any objective sense, which then allows judgments to be made about the worthwhileness of the person's life. A true notion of best interests, I think, and it ties in a little with what Anthony was saying about the importance of defining the good, is to have an objective understanding of what is truly good for us, which includes the good of life and the good of health. And there have been occasional judges who have sought to tie the notion of best interest to those objective concepts. But unfortunately, it seems the prevalent judicial thinking these days is simply to buy into the wholly subjective notion of best interests as articulated in the Mental Capacity Act.
I suppose in 40 years of medicine, as a doctor, I've helped many suicidal patients, but I've helped them to live and not to die. And I think one of the practical and philosophical problems we have here is a lot of people who want to die change their mind. They can't change their mind if they succeed, but from a practical point of view, the desire to kill yourself is not absolute.
Yeah, I was just wondering whether you had considered the issue of medical futility in terms of futile treatment, and whether that has influenced or has an impact upon your argument, basically.
Yes, there's never been any objection to withholding or withdrawing treatments on the ground that they are futile in the sense of not offering any reasonable hope of therapeutic benefit. So many cases of withdrawing or withholding treatment are perfectly morally unobjectionable, and the law has long recognized that. The problem in the modern era is the concept of futility has been confused with the notion of the futile life. So as in cases like Charlie Gard's, courts are engaging in the kind of objectionable reasoning that says the reason this treatment is futile, even though it would benefit you and keep you alive, is precisely because your life is futile in our judgment. Your existence is awful. And if one takes that step, then one forfeits any principal objection to administering lethal injections. So I think it's really important to keep clear the distinction between a futile treatment and a futile life. And unfortunately, that distinction is largely, it seems to be blurred in the bioethical literature and in the courts.
Professor Keown, I'm interested in your perhaps your experience or insight into whether positive obligations to uphold the right to life have ever or have the potential to be a strong enough bulwark against deliberate suicidal intent, in that if we accept it on the one hand for people who are very capable, who have a great deal of autonomy, can control what happens to them, but it still opens up the conditions for those who are vulnerable to have their lives ended. Is there a strong enough argument there that can be used to preclude permitting assisted suicide?
Absolutely, because it seems to me the principle of the inviolability of life holds that one's life has an intrinsic dignity, irrespective of what one thinks about it. And the minute one abandons that judgment and that principle and holds that the value of life is determined by your evaluation of it, one buys into the kind of school of thought of Ronald Dworkin and John Harris, which is your life has value to the extent that you give it value. So I think that's a deeply objectionable alternative principle. And of course, not only in principle is it wrong, but also in terms of the risk to vulnerable populations, because how many are those who could easily be persuaded that their lives actually lack value and be encouraged to request euthanasia? So that's why I think the role of the disability movement in resisting moves towards legalization of physician-assisted suicide is so important, because it flags, very importantly, the value of each person, however abandoned, lonely, disabled, unwanted they may feel. And one can see, I discussed this also in the second edition of Euthanasia, I think it's a public policy. One can look at the trend, the continued downward trend in the Netherlands, where there is a very strong move to legalize assisted suicide. It wouldn't necessarily be physician-assisted suicide for those with completed lives. So it emerges there are many, many thousands of elderly people who are lonely, and they have been agitating for the right to access to lethal drugs. And of course, in 2016, the then Dutch government proposed that the law should be extended to allow them access to lethal drugs after consulting 2 death counselors, psychologists. And then a piece of research that was done among people who thought their lives were completed and were suffering existentially was extremely moving. The researchers said, we interviewed these old people, and it was really remarkable how unwanted and insignificant and abandoned and meaningless their lives were. So the researchers themselves were saying, surely we don't want to make it easier for these people to access lethal drugs. We should be helping them to rediscover value in their lives. So I take your point. There's a principal problem that the value of one's life does not depend on how one values it. But also, if one went down that road, many are the people, the marginalized, the disadvantaged, who could very easily begin to think, whether with persuasion or not, that their lives lack value.
Thank you.
Thank you. In the first part of your talk, you clearly showed us how the law relies on science and medicine to draw some lines. For instance, the primitive streak, the conception of viability. And you also clearly showed how these lines can be incoherent. So, but on these matters, on these issues, the law cannot make any judgment without the help of science and medicine. But sometimes it looks like he does that in a manipulative way. Do you think there is another way to what judges and lawmakers can deal with those issues being honest and coherent with the science is telling us today, because science and medicine are still in progress?
Well, I think one of the problems is that, to a large extent, judges are simply reflecting the modern world in which we find ourselves, in which utilitarian thinking and dualistic understandings of personhood are very prevalent. And I think they're reflecting the influence of modern bioethics, which buys very much into those notions. Maybe they themselves have studied law, taken courses, and have been taught by professors who advocate those notions and who don't perhaps give adequate time to the alternatives that I've been suggesting tonight, which are actually, as it were, historically built into the law. So I think it's very important to try and educate the judges as well as legislators, and to direct papers and research specifically at them to try and help them to see how a notion of intrinsic human dignity, which is tightly connected to human biological life from its beginning to its end, is actually a very kind of historically part of the common law tradition. And so I would hope that the Biocentre would maybe take on board the challenge, to whatever extent it can, of addressing judges in some shape or form, perhaps writing papers specifically directed at them, to bring to their attention some of the ideas that I've been drawing on tonight.
Okay, I think that was the final question. People can maybe one more after this.
So I understood you to be against a kind of subjective approach to understanding best interests and therefore ideas of substituted decision making, but at the same time accepted the idea that a competent person could refuse unduly burdensome treatment. And I wonder how you reconcile those two approaches in what seems to me to be discriminatory, like to the incompetent people who may therefore have to undergo treatment that they would deem burdensome.
Well, I didn't really say anything in principle to object to substituted decision-making. My main criticism was about the concept of best interest, which is defined in a wholly subjective way, which allows a person to say that their life has no value and that they'd rather be dead. And I find those kinds of judgments objectionable, and those kinds of judgments which have no right to be respected, basically. So one can think of examples of where one leaves a specific request and then one falls into a state of incompetence. I don't think it follows that we have a duty to carry out whatever request it was that the person made. I was discussing with a transplant physician the other day a case where someone says, well, after you've declared me dead, you can take my organs, but don't give them to a black person. We would surely override that request, as I think transplant teams do. They just say, well, that's a gross and offensive expression of that person's wishes. It's a racist expression of wishes, and we're not going to comply with it. So I think it's important that just because someone leaves some kind of advance directive or expresses some kind of opinion, it shouldn't follow that we automatically implement their wishes. We need to have some objective notion of whether that is the kind of wish that ought to be respected. And generally it will be. A patient might say, you know, I wouldn't want that kind of treatment if I were incompetent because it would drain my resources and I really want to leave enough money to send my kids through college. So there are all sorts of perfectly proper ethical expressions of opinion and wishes that we have. But my point is simply that not all of them should be followed just because they were the expression of a request.
One brief final question.
Can I just ask about the current sort of situation here in the UK, where often if you've got a hard case at the end of life where someone assists someone else to die, the prosecutorial authorities will not prosecute generally. From the point of view of having a sound philosophical view on those sorts of situations, how do you think those in the pro-life movement and the anti-euthanasia movement should respond?
Well, I think in principle there is nothing objectionable with a decision not to prosecute if it would not really be in the public interest. So, of course, the two criteria that the prosecutor has to satisfy, or is there more than a 50% chance of conviction, so is there a realistic prospect of conviction, and is it in the public interest to prosecute? And in a number of cases, it's not in the public interest to prosecute. So I don't think in principle there's anything objectionable to non-prosecution in cases of assisting suicide, provided it doesn't become a form of de facto legalization. And that's where one has to look to the discretion of the DPP in particular to be exercised scrupulously in accordance with the appropriate criteria. But it's certainly a vastly preferable situation to the legalization of physician-assisted suicide. And I think it's unfortunate that the Director of Public Prosecutions was forced by the Supreme Court to actually issue guidance setting out the criteria which would lead towards a prosecution and lead against a prosecution, because it seemed to me that was effectively giving people clear guidance on how to evade prosecution for a criminal offence. So I think the Supreme Court's decision was a bad one, was poorly reasoned, but the DPP had to comply. So I think one could say, look, to those who say the law is cruel and uncaring, well, it isn't, actually. It's always had this inbuilt flexibility. Not every case needs to be prosecuted. And there may be sound reasons in individual cases why it is actually understandable and acceptable that this particular person isn't put through the criminal justice system. So I think we can live with a system where the decision is ultimately left to the DPP and use it as an illustration of how flexible and accommodating and compassionate the law actually is.
I think that's a very good moment to end. So thank you very much indeed to Professor Keown, who's come over, and thank you very much, all of you, for coming. Please do sign up to the BIOS Centre via the website to keep in touch with what we're doing, or just email me directly if you know me personally. And thank you very much indeed for coming. There's more food and wine, and please do feel free to mingle into the night. Thank you. Thank you. It wasn't quite your title.